Greetings and welcome to the Husch Blackwell Health Law and Innovation Virtual Series. My name is Tom Shorter. I'm a partner in the Madison, Wisconsin office of Husch Blackwell and a part of the Healthcare, Life Sciences, and Education Business Unit. This is the fourth in our series, virtual webinar series, and we will be talking today about litigation risk issues that we all see coming down the pike. And some of them that are right in front of us right now. Before we begin, I'd like to do a few housekeeping items for your benefit. At the bottom of the screen, you should be able to see an audience console with several icons, application icons. If you have questions today, please use the question icon, and we will try to leave a little time at the end of the session today for questions if we can. But rest assured, if for some reason we're not able to talk today in the time we have allotted about your question, we will do follow-up to anyone who submits questions. We'll get an email answer to you. So thank you for using that and submitting questions. The materials are available to everybody today in the resources folder. For those who would like continuing education legal credits, you click on the CEU icon at the bottom of the screen. You will get a certificate of attendance, including the course numbers, and that will be emailed along to you tomorrow with the recording of today's webcast in case you want to play it one more time or be able to share it with any of your colleagues. Toward the end of the program, we will also be asking everybody to complete a short survey. This is helpful to us to provide feedback on the needs and interests of your business, as well as to decide where we may have topics that our audience would like to hear more in depth about. Okay, these are the future sessions. I referenced them a moment ago. This is the fourth again in the series, and the prior sessions are available on recordings. These are the upcoming ones. And we would encourage you to register for any or all of these. There's some really good, interesting discussions coming down the corner here. You'll see. So again, please do go ahead and register for those if you're able to do so. So today's webinar session is on risk management and our uncharted waters. Clearly, this is an area with the COVID situation that has been with us now for a good solid 8 months. And that's going to be a point of some discussion among the group today. And a little bit of prognostication, a little bit of actual cases that are going on. We're going to cover a whole bunch of things. Let me walk all of you through first, however, who we have with us that are going to participate in the panel discussion today. As I mentioned, my name is Tom Shorter. And I'm going to be moderating our 4 panelists today, and it's an honor to be able to do so. So let's first talk about our guest panelists. Our first guest panelist, Dr. Anthony Burgess, is the Chief Medical Officer for Tutera Healthcare. He's in a role to oversee clinical and medical operations, manage provider relations, regulatory compliance, risk management, and fiscal responsibility. He's very involved in the Society for Post-Term Care Medicine and serves on the Leadership, Innovation, Risk Management Committees to change at the local, state, and federal levels. So thank you for joining us, Dr. Burgess. We are also pleased to be joined by Maria Ganson. Maria is the Vice President and Deputy General Counsel with Christus Health in Irving, Texas. She has over 20 years of experience as a trial attorney representing healthcare institutions in several states, Texas, New York, California among them, on catastrophic injury cases and other healthcare representation, including peer review and regulatory matters. Well, pleased to have Maria join us as well, a wealth of knowledge for sure on litigation matters in healthcare. We are also joined by 2 of my partners at Husch Blackwell, who bring also a wealth of experience. The first is Jody Rudman. And Jody is a partner in our Austin, Texas office, also part of our Healthcare, Life Sciences, Education Business Unit. Jody has assisted clients across a wide range of industries in investigations, negotiations, mediations, pretrial, grand jury proceedings, civil lawsuits, criminal indictments in some cases as well. Has more than 20 years of experience representing clients in all phases of litigation. So thank you, Jody, for joining us as well. And our fourth panelist today is Kevin Karanka, another of my partners, also from our Austin, Texas office and a member of our Healthcare Life Sciences Education Business Unit. Kevin frequently works with healthcare systems and providers on a wide range of employment matters, including high-level investigations, leave and accommodation issues and concerns, discrimination, harassment, non-competes, reduction in force, and other sensitive terminations. So as you can see, and thank you for joining us, Kevin, as you can see, we have a wide range of perspectives today. So I am very excited to be able to hear from our panelists. I hope you are as well, and get some different perspectives on what's going on from a litigation standpoint. So here's generally where we're going to go today with the discussion, and hope this you enjoy this discussion. We're going to talk a little bit about litigation trends in healthcare, obviously gaining some different perspectives from our panelists. And then we are going to transition to talk about real life case examples, things that are going on right now that you should be aware of that present risk issues to be addressed by healthcare institutions across the country. And then we're going to hope to wrap with some strategies to implement, some practical insights from our panelists on things that your risk management teams should be aware of, thinking of, and maybe even actually implementing at this time. So as we start this discussion, we have a few survey questions, poll questions for the audience. It helps us get a little bit of a sense of thoughts from our audience members. You'll be able to answer these poll questions as we go. So I'm going to throw up the first question here, and you should be answered on your screen, and I'll display the results momentarily. So the first question: has your organization been involved in COVID-19 litigation? Have you been involved in COVID-19 litigation? We'll give everybody just a moment, and then we'll switch over to the poll results in a moment here. Okay. So I can see as folks are still entering some answers, so far the answer pretty predominantly is no. A great thing, obviously. And I think you'll hear from some of our panelists today some prognostication about whether that's going to continue that way or not. But I'm glad to hear that it has not yet settled in for many of our audience members. That's good. Second question: has your organization devoted increased resources to COVID-19 risk management? So again, has your organization devoted increased resources to COVID-19 risk management? Okay, we'll give everybody a moment to answer that question. Okay, pretty overwhelming on this one as well, that a good percentage of our audience today has putting more resources on this. And so clearly this session and discussion, I think, will rest well with all of you as to thinking ahead and putting resources into risk management planning. Our final question today: are you a member of your organization's management team? Again, are you a member of your organization's risk management team? Give everybody a second on this one. Okay, we'll see as people are results. Whoop, I went too fast. Apologize for that. There we go. All right, so good. We've got the right mix in an audience today. Some folks clearly tied in on the risk management side. So thank you for participating in those survey questions. Again, helpful for us as we think about our comments through the session today. So let's actually start off our panel discussion. And as I mentioned, we wanted to talk about what our panelists see in some of the litigation trends in healthcare. And I'd like to start out this discussion today with you, Dr. Burgess, if you can provide some thoughts and insights from your vantage point about what you're seeing in terms of potential risk areas and potential trends as it relates in particular to long-term care, which of course we know has been really very much at the center of a lot of the COVID-19 issues across the country. So Dr. Burgess?
Thanks, Tom. So just like the farmer's commercial, and not that I'm promoting, but we know a thing or two because we've seen a thing or two. And we are seeing dramatic changes with regard to litigation, and not in a good way. In the beginning of the year, we were proceeding as always, business as usual. And then SARS-CoV-2 or COVID-19 arrived on the scene in early March for us. And ever since, we've seen countless positive COVID cases with unfortunate death, right? We all know this. Not surprising, there was a window of time during the shutdown when we had no legal activity. And it was disturbingly quiet. In this case, no news was not good news. We are now seeing an uptick in the sheer number of cases and the type. Almost as if the plaintiff attorneys were either sitting on these cases or they need to make up for lost revenue. Not quite sure, it doesn't really matter. But what we do know is that we are now on the receiving end of anything and everything. And the bulk of these are simply not COVID positive cases. What we're seeing is a fair number that are COVID related or secondary effects of, such as wounds, falls with injury, malnutrition, abuse, neglect, changing condition, failure to thrive, etc. Essentially, the isolation, the immobility, the lack of visitation, interaction, and communication has given rise to these age-old problems. Now they're real, but many of these are disguised in that they're not direct COVID-related cases. They're now asserting that these are all the result of COVID. So they're hiding these in some way. And so we, obviously, nursing homes were the first to garner the media attention. Lifeline Center in Kirkland was the first, ground zero, we call it, for our industry. And to date, there were 129 COVID positive cases and 37 deaths at that site alone. And then in April, the first COVID lawsuit happened. And there have been many more, and we'll talk more about that. But nursing homes in general have been stereotyped or portrayed as evil, just money grubbing, deceitful entities, pushing profits over people. And now with COVID, the media has twisted the public perception to fit this false narrative. We're not the bad guys. We all see, hear, and read the cases and the deaths and how negligent or bad nursing homes are on every media source. And initially reporting about COVID cases in a nursing home was groundbreaking news and got everyone's attention. And no doubt at first we were caught off guard, we were overwhelmed, undermanned, we're unprepared, ill-equipped, you name it. And the message was, do not send your loved one to a nursing home unless you want them to get COVID and die. And plus, you can't visit them. And so as a result, there was a mass exodus of patients leaving our settings. And then as months went on, the virus has penetrated every sector, level of care, household, even the White House, the state, the countries, you name it. It is no longer all on us. In fact, we're now kind of looked at as like the poor guy. So the perceptions were initially, hey, we were at fault, no ifs, ands, or buts. But now I believe the public is seeing the bigger picture that this is a worldwide problem that can't be contained. And frankly, we're all at risk. And there's some grace being given right now, and it's not just us. We're finding that there's problems worldwide. And in America, we have these regulatory bodies that help oversee and control things and so on. But CMS, the messaging has been very inconsistent at best. And we hear two versions. One, we're here to help you and support you in any way we can. And the other is you will comply with what we tell you with regard to COVID or else face citations, fines, sanctions, loss of license, et cetera. And then we have the CDC, the FDA, the state and local agencies with incongruencies. Guidance changes every month or week, depends on where you are. And of course, the mixed messages. Essentially, every level is passing the buck and the blame to the next until it falls on us to figure things out. Kind of like MacGyver, we got to fix something with nothing. And the CDC says this, the states say this, the county health department says this, and they're not all the same. And so mistakes are happening. And this is attributed to misinformation, misinterpretation, misunderstanding, misguidance, mishandling, misstep, you name it. And this has proved extremely challenging for us. And so we are seeing many effects of COVID, not in a good way.
Yeah, clearly the media pointing fingers, I think certainly leading to a series of challenges towards the long-term care sector based on residents and families of residents. I think one of the other interesting areas, and I'd like to sort of transition over, if we could, to talk is the employees. There's lots of employees that are working within healthcare. And of course, I think everybody here knows that employment law issues equally sort of surface up here. It's not just the patients and the families of the patients, but the employees themselves. Kevin, let's get a little bit of a vantage point from you as an employment law practitioner, what you see as potential trend lines in this area.
Sure. Thanks, Tom. Similar to what Dr. Burgess said about the long-term care setting, we're definitely seeing quite an uptick in employment-related claims across the healthcare industry due to COVID. In March, when the pandemic hit, with little advance warning, our clients were forced to try to determine how best do you protect these essential frontline workers while they're also balancing the fact that they're trying to transition some of those other workers to a remote work or a work from home model. And then there's the added distraction that you have to furlough or lay off some of these folks. With all those moving parts and sort of the inconsistencies in guidance, whether it be from CDC, OSHA, CMS, differences in local government orders, I think that created a real struggle for our clients and providers to figure out what exactly to do. And I think due in large part to the confusion, there have been a number of lawsuits filed. There have been a number of OSHA citations issued over the last 6 months against healthcare employers. Healthcare has definitely been the hardest hit industry. At the same time, when you have all that going on in the background, Congress rolls out this new law called the Families First Coronavirus Response Act, which we now know provides federal paid sick leave to some, but not all healthcare employees. Trying to figure out, does it apply to your company? How do we calculate the 500 employee threshold? Who's eligible for emergency paid sick leave? Who's not? Should we exempt some of our employees, all of our employees? That new legislation has really started to generate a lot of new lawsuits by employees complaining that either they were improperly denied leave or they were wrongfully discharged or retaliated against for requesting that sort of leave of absence. And on top of the FFCRA, just like the OSHA and CDC regulations and guidelines, it's even more complicated because you've got local states, local cities who are rolling out additional paid leave requirements over and on top of what the FFCRA might require. Typically when we look at these employee leave cases, disability accommodation cases, you see them brought as charges or lawsuits by individual employees. Classic examples like failure to accommodate under the ADA, FMLA interference. Those are all usually cases that are brought by individual single plaintiffs, employees suing on their own behalf only. Now COVID's giving rise to all these unique employee leave issues that I think, if not handled properly, really open the door to potential class action litigation. With so many employees working from home as well, there's a heightened risk of FLSA collective and class action cases if employees aren't tracking their time right, non-exempt employees, that is, because it's tough because they're at home trying to juggle work and help with their kids' online school, got all sorts of other issues going on. It's hard to track all that correctly, so that there's a big, I think we're going to see a lot of FLSA claims filed in the future. And you fast forward a few more months, everybody's starting to get their feet underneath them in terms of how best to address these issues. And now you're seeing employees who've been working from home who don't want to come back to work. It might be because they just like working from home. It might be because they've got a medical issue or a childcare issue that won't let them come back to work while the pandemic's going on. I think that really makes things ripe for whistleblowers to either go to the government or file whistleblower lawsuits about what they perceive as shortcomings by their employers. They think they're being retaliated against for raising these concerns. We're seeing a really big uptick in that sort of litigation. Really, our clients are just sort of facing a constantly moving target on these sort of employment issues. So we'll take some time today and I think walk through some of the litigation that we've seen to date. Also talk about some practical strategies around, how you might avoid or mitigate against some of those risks. But it's a mess, that's for sure.
Yeah, that's an interesting sort of summary of it, right? Some of the mess that is there, and I'm sure a lot of those comments probably ring true on the employment side litigation to Maria. Let's transition over to you, Maria. Clearly, there's, I'm sure, some of those examples Kevin talked about, but you're in the midst of, I'm sure, lots of litigation trend line monitoring for Christus. Give us your thoughts. What do you see as our trend lines that are going to continue in the litigation space?
Well, thank you, Tom. As far as for the hospital community, and I see several folks on the attendee list are hospital affiliated, we have not seen direct COVID cases yet. I know they're coming. I believe that the cases that we've seen come in relative to falls, things that are going to have COVID as a secondary aspect of the negligence med mal claim, is going to change the way we defend cases. Think about the patient fall where traditionally you'd have a family member in the patient room overnight. Patient family visitation has ended or is extremely limited in most hospital settings. So falls are going to become more complex because it's going to be, you can't rely on the patient family member as a sitter. That's just one example of how I think our medical negligence cases are going to have a COVID overlay. ED care. The ED setting has changed entirely throughout COVID. So now ED settings, you have situations where patients are waiting in their cars and maybe they're having a soft triage in their car as they're waiting for care. I think that's going to give rise to new forms of triage delay theories in our ED litigation. So it's a little too soon to tell from the for acute hospitals in terms of what medical negligence is going to look like, but I'm convinced there'll be an overlay for COVID. In our world of medical malpractice, the trend that I think is probably the most disturbing that I've seen here in the last 5 years is the increase of the catastrophic damage, the size of the catastrophic damage case, the life care plans. Used to be that life care plans were solely the province of the birth injury and the child with cerebral palsy. We are now seeing life care plans coming up in our surgery cases and our retained foreign object cases. The life care planners are out there doing pretty good marketing for themselves because they're appearing in a lot of cases. And as COVID, you put the COVID overlay on this, I think we're going to see perhaps life care plans for COVID patients that are going to potentially bring suits. Now there's a subdiagnosis known as the long haulers, people who have had COVID for weeks and weeks and weeks, and it has resulted potentially in permanent damage to their pulmonary system, their renal system, their neurological system. Scientifically, we don't know how the virus is affecting every body system, but I'm convinced that in 5 to 10 years, we're going to see life care plans for COVID cases where we have these large catastrophic damage numbers due to a life care plan focused on COVID. I think it's going to have the reptile theory is something that in the defense world we deal with a lot. I think if you think about the reptile theory and the whole premise behind that theory is that hospitals are supposed to provide or are criticized for failing to provide a safe environment. And the reptile theory is a way to get around the standard of care and negligence litigation. I think that safety and patient safety and COVID go hand in hand. So I think we'll see a new development there. And then on upstream liability, which is something we deal with in hospital systems that have corporate structures with parent corporations, we are seeing more and more corporate liability type theories where the plaintiff's bar doesn't wish to sue the individual practitioners because their limits are so low. So instead they want to sue not only the hospital, but the parent of the hospital. And so we see a great deal of that type of litigation. And I know we're going to touch on the HCA case in California, but when you look at the way our corporation addressed COVID was a corporate, looking at the CDC guidelines and determining protocols and policies. And if you take a look at the HCA complaint in California, that's exactly what the personal injury bar did. They took the CDC requirements, they listed them all out, and then they compared how the corporation, or their allegation as to how the corporation responded to it. So corporate upstream liability, I think, will be something that will evolve and devolve in a way that we can't really totally predict, but I think it's something we keep our eyes on.
Yeah, clearly, it was interesting, of course, to hear you say, and I've noticed this even myself, as some of the recruiting of plaintiffs strategies have begun. We've certainly seen that start to happen in different communities for sure. So clearly, the plaintiffs bar will be active in looking for cases. But in addition to the of course the plaintiffs bar, we of course we also have the federal government looking over the shoulder of all of our clientele in the healthcare industry. Not new that they're looking over the shoulder, but of course there are some new reasons for them to be looking over everyone's shoulder and maybe questioning how things are being handled. Jody, let's get a perspective from you. Where do you see the government enforcement trend lines going in the healthcare side?
Right. Well, thank you. As a former federal prosecutor, so much of the work that I do is in the government investigations and prosecutions and False Claims Act space. And although things were certainly plenty busy in the healthcare sector in that space pre-COVID, it has basically exploded, and I anticipate that the explosion will continue for quite a long time. The Department of Justice has really made very public its intent to prioritize pandemic-related enforcement activities. That's not going to go away anytime soon. Most federal criminal statutes have a fairly long statute of limitations, so there's a lot of lead time to work up federal investigations. So in my opinion, we're likely to see this long after the acute phases of the pandemic are behind us. But to flesh that out a little bit, the U.S. attorney's offices in each judicial district, I believe, have all appointed coronavirus fraud coordinators. Many also have task forces that they've put together to coordinate law enforcement efforts. Those task forces are additive to pre-existing healthcare fraud task forces in some of the bigger jurisdictions, so they don't replace them, they add to them. To date, the Department of Justice has announced 33 fraud cases, 11 civil actions, 50 PPP cases charging 65 defendants, and in those PPP cases alone, what's at issue is some $227 million in PPP funds. So these are very significant financial cases. There's a lot more coming down the pike, I believe, if you just look at tips and hotline reports. For example, the National Center for Disaster Fraud reports that it's received 76,000 tips. The FBI reports that it's received over 20,000 tips. The SBA Fraud Hotline reports that it's received over 42,000 reports. So you can imagine that statistically, those are going to blossom fairly significantly into some heavy-duty investigations and litigation. If I were to forecast and basically describe what I think is kind of the here and now, and then what I think is maybe more middle term, and then more kind of a little further out on the horizon, I would suggest the following. I think that what's here and now and probably going to stick around for quite a while is the fraud cases in connection with applications for and then the spending of PPP loans. And I think there will be some spinoff on the loan forgiveness program, on that side of the PPP litigation. Also here and now are hoarding and price gouging cases and investigations. A little more mid-range are going to be, I think, labs, dubious cures and treatments, and then nursing home litigation. And I'll just break those down super quickly. In the lab space, we entered into the pandemic already with labs fairly well under the microscope of the DOJ. In September of 2019, the DOJ announced a big takedown in what they called Operation Double Helix, which had to do with kickback allegations involving labs and lab marketers who were marketing cancer genomic and pharmacogenomic tests, sometimes referred to as cancer genetic and pharmacogenetic tests. And that all dovetailed with the telemedicine industry and then the lab industry. And there was a number of prosecutions in Operation Double Helix. And DOJ was also in the process of investigating pretty heavily laboratory pass-through billing and its connection with rural hospitals. So that microscopic view of labs and those investigations have not gone away, but the lab space is under yet further scrutiny because now that the pandemic is upon us, there are assertions and allegations of additional kickback issues and then the bundling of potentially unnecessary tests with COVID-19 tests. So there's particular scrutiny on RPP or a respiratory pathogen panel testing and whether those are improperly bundled with COVID tests and whether there are kickbacks to induce the orders of those tests. So I think that space is probably going to be fairly heavily litigated for the next several years. And as I mentioned, dubious cures and treatments, that's a little more midterm. We've seen some prosecutions. Certainly the FDA has gotten very busy issuing warning letters. The nursing home space, I am afraid, is going to be a hotbed of investigation and litigation. And then finally, in the longer term forecasting, the auditing of the CARES Act provider relief funds and the gleaning of recipients' attestations and then their compliance with terms and conditions will no doubt result in some investigative and enforcement activity. I think it's a little too soon to even be seeing that or to be charting that, but I think it'll be there. And then finally, longer term, my guess is that there will be some payors that are running analytics and trying to pursue providers that they believe were involved in the ordering of unnecessary care or are well on the fringes of high level use of very expensive care and treatments and testing.
Yeah, some scary stuff in there that may be coming down the pipe for sure. Now, each of you had through your presentation or discussion on litigation trends, referenced or alluded to some of the stuff that's actually happening now. And as I mentioned earlier as well, again, there is some activity that's been happening on the litigation front. What I'd ask, and we're going to run through with each of you an opportunity to talk a little bit about an example or two within the space and from your vantage point where you're saying this is a case that we really need to make sure from an industry perspective that our audience has got their eye on. So I'm just going to run through with each of you. If you could talk through an example, Dr. Burgess, maybe we'll kick that discussion off with you if you want to pick one or two of those examples that we've got listed and walk the audience through that.
Sure. No, what we do know is most of the 220,000 deaths in the U.S. from long-term care settings, right? That's on us. And in fact, the Washington Post reported that 47% of the 222K are elder home residents. Now, those are only the cases that we know about. I suspect that number to be far greater than 50%. And no surprise, we're seeing a record number of COVID-19 lawsuits, right? Direct and indirect, wrongful death, negligence, even gross, willful misconduct, elder abuse, medical malpractice against providers for not diagnosing or treating COVID in time, and even take-home lawsuits in which an employee brings home COVID to a relative or family member and then sues us, the employer. And sadly, this is all turning tragedy into legal action and basically profiteering on misfortune, but that's neither here nor there. These all revolve around the response, the lack of pandemic preparedness plans. None of us have ever experienced anything like this. We're just kind of fumbling our way through it, but it all comes down to inadequate infection control measures. This is nothing new, but now it's more pronounced, right? It's more focal in the lack of adequate personal protective equipment, PPE. No one could get it. It was crazy expensive. If you did, it was black market stuff, whatever. Lack of testing, right? Not enough labs, no reagents, logistic issues, you name it. Not enough tests. Inadequate staffing, nothing new again here, but now more evident. And of course, negligent decisions at critical times. We've never had to be the decision maker we relied on guidance. Well, we weren't getting that. So we had to make decisions on when and how long to quarantine people, patients and staff. And it was a failed response on many levels. And of course, now the blame falls on us. So I call it dysfunction junction, maybe a setup for failure, if you want to call it that. But I look at, the actual harm cases, but now we're receiving some workman's comp claims that are not from disgruntled employees, which we expect those, right? Those are a given. But now we're getting these, just like Maria referenced, the COVID-19 persistent symptoms, the patients who are not fully recovered. And these are called the long haulers, and not the trucking industry people, but these are people who've had symptoms for months with no end or resolution in sight. And some have had permanent impairments, just like she referenced. Every system is up for grabs, and these individuals are unable to fulfill their role. So now we're thrown into this other arena. So not all the states are in agreement on this one, and some have stalled most cases, but I foresee that we're going to see more of these cases in the months to come. And these are only just a few examples, but I referenced a couple there on that I've seen, and these are not our cases to be confidential and everything, but nationally there are hundreds, basically more than I want to count. And to my knowledge, there's no national database that tracks all these COVID cases. But many of these plaintiff attorneys are now submitting a few just to kind of get a little in there. They're stockpiling the rest for next year, waiting for judgment on these test cases. And so I give everyone caution. Brace yourself for what is about to become what I call the COVID tsunami of lawsuits. It will be essentially sink or swim. And I don't know about you, but I choose to be like Michael Phelps and swim at them. So we're ready.
Yeah, no, I agree. And I appreciate that perspective, Dr. Burgess. Kevin, clearly, the employment cases, I'm sure, have continued throughout. And maybe if you want to highlight a couple of items that you've seen in particular that relate to some of the COVID activity.
Sure. Yeah, as you might expect, the healthcare industry has been the hardest hit by employment lawsuits. The tracker that I've seen on the employment lawsuits, it's almost triple the number that have been filed against the next, most active industry, manufacturing. But as Maria mentioned, one of the cases that's definitely generated the most press recently around these employee workplace safety issues is SEIU versus HCA. And that's a lawsuit that was filed out in the state court in California by the largest healthcare labor union in the nation against HCA, which is the largest hospital system in the nation, in the local hospital there. The plaintiffs are unionized employees. They allege basically that HCA and its hospital didn't follow CDC guidelines.
Oh, looks like we may have lost Kevin for a moment on a connection issue. Maybe while we're having Kevin get himself reconnected, why don't I actually Kevin, are you there? Well, why don't I kick it over to you, Maria? You've
Sure.
probably seen many of the same kinds of cases actually that Kevin has seen in your role, but also just to give some thought on the risk management side, a good example or two for our audience of what's active now.
Sure. I think everyone should be watching the HCA lawsuit in California. I mean, granted, it's a lawsuit that's driven by the union, but it involves phlebotomists that are asserting they weren't given PPE. They were made to buy their own PPE. They were made to work while they were symptomatic or ill. I think that lawsuit bears watching. And I do think it's probably been put up as a test case. But from our perspective, as I look through the hot trends, which, we just came out of the National ASHRM meeting last week, I worry about some things. Again, I talk about the COVID overlay. A couple of the cases I've cited here, you can go look them up. But the opioid abuse case out of Virginia is a case where a physician was trying to have a court dismiss the punitive side of the lawsuit. He'd actually stipulated to negligence in his prescribing practices for a female patient who had a history of alcohol abuse and bipolar disorder. And that physician did not succeed at that. I think the trial court granted his dismissal of the punitives, and then the Virginia Supreme Court found that because he had demonstrated reckless conduct in the amount of prescribing he was doing, and the fact that he never saw the patient over 51 instances of repeated prescriptions, which totaled hundreds of doses of, I think it was Percocet, the Supreme Court of Virginia found that that was sufficient and would not eliminate the punitive risk for him. I think that as we are doing telemedicine as providers, as we are not seeing our patients in the office, I think it comes down to being more overt about our documentation, of documenting the telemedicine visits really robustly. Because again, you're not going to have the ability to say, well, I know she was in the office, I know I saw her, and I know we had a visit. And from a telemedicine standpoint, you're going to have less to work with as you're trying to remember something 3 years later when you're in litigation. So those cases highlight why I think the COVID experience have changed the delivery of care, no question about it, and why as providers and as risk leaders who counsel providers, there are some things that you can really do to be protective of your delivery of care. The other case is a res ipsa case, which basically eliminated the standard of care when it came to negligence around a retained foreign object, which in those two cases, it was nothing that was counted like a sponge, which we've traditionally seen in our retained foreign object cases. Those are guide wires that are not part of the count that were left in, and the Supreme Court in Nevada decided that those did not require any form of, it was automatic negligence, and the burden is shifted on the defense to prove there was no negligence. And then the last case I wanted to highlight is EMTALA. It's more of a case about how EMTALA standards are not med-mal, but I do want to mention again that as we are delivering care differently in the COVID pandemic from the emergency room standpoint, as we are talking to patients in their cars, in instances where we're doing that kind of delivery before they come in for protection, I think there's an EMTALA risk there that we have to be mindful and make sure that we have the protocols and the policies and procedures that intentionally consider our obligations under EMTALA, as well as standard of care delivery of medicine, because the framework is so different when you have a triage nurse talking to somebody on the phone over when they're in their car. So those are three kinds of cases I think are hot right now, just simply because they'd be hot without COVID. But when you put the COVID overlay on these circumstances, it makes it really dangerous.
Yeah, for sure. Great point, Maria. Great point. Maybe we talked this for a moment as well, Jody. Fraud and abuse. It's present, but you referenced, as we talked before, some items. Why don't you talk through a couple of examples of active items on the fraud and abuse side?
Sure. Yeah. And in the interest of time, I won't hit all of these bullet points, but I will just zero in on a few that I think might be of particular importance to those who are attending today. I would keep my eye on what's going on in the lab space, as I mentioned earlier, not only the actual indicted cases and the theories behind those cases that have to do with kickbacks or the improper bundling of unnecessary testing. But in addition to that, Chairman Frank Pallone, who's the chairman of the House Energy and Commerce Committee, which has oversight over the Families First Coronavirus Response Act, has on the committee's website some information that's very public about some letters that committee has issued seeking information against allegations of surprise billing, or excessively high bills, unnecessary testing. And I think it would be smart to keep an eye on how that committee and its investigation progresses, in addition to the actual indicted cases. And I want to share that in connection with that, the use of the ECRA statute, which was passed in 2018 with kind of little attention and little notice, is probably something that ought to garner a little bit more attention here post-pandemic, in that what ECRA is an all-pay or kickback provision, or anti-kickback provision. So it applies to payors, even outside the federal government. And if there's kickbacks in the lab space, they can be addressed under ECRA. And I think that's I think it's smart to pay attention to that. There's only been one prosecution under ECRA so far, and the defendant pled guilty, but it will be dragged out. And then the other sort of highlight, I guess, from this list would be the nursing home cases. Hopefully these are an outlier. The Massachusetts Attorney General filed criminal charges against the medical director and the CEO of a veterans nursing home in Massachusetts based on that nursing home's handling of the pandemic and the terrible outbreak at that facility. And I hope that that's an outlier. I hope that the filing of criminal charges is also an outlier, but it's one to keep an eye on, because in addition to that Massachusetts AG filing those charges, there are federal investigations. HHS OIG has investigated skilled nursing facilities in Massachusetts. There are 2 Pennsylvania nursing homes that were raided by the FBI with search warrants seeking evidence related to their infection control practices and their sanitary conditions. That has not yet blossomed into charges, but I think that's worth noting.
Great. Thanks for that, Jody. I appreciate that. And for all of our audience members, obviously, as I mentioned, the slides are available, and so you can pull these cases up, take a look at some of them that our panelists are watching themselves when they're thinking about risk mitigation and strategies. And of course, we'll provide email addresses for all of our panels so you can ask questions about any of those cases that might be of interest. What we'd like to do now is really spend the time. We've talked about some of the trend lines that we're seeing from different angles within the healthcare industry and given some real examples of cases going on right now. Would like to spend the remainder of the time before we try to leave a little bit for Q&A to talk about some practical strategies. This is really that idea of, what can you do now? What are the things that to sort of keep your finger on the pulse, get some work done, some planning done to prepare for this tsunami of litigation, as Dr. Burgess referred to it. So, Dr. Burgess, let's actually turn to you first on this one. A point or two that you think is a really important strategy for, risk mitigation to implement now?
Sure, Tom. There's no one size fits all, and there's a ton of options for us. But I make it real simple. Taking care of people in the post-acute long-term care space is risky business. But the risk can be mitigated with following a couple things, right? And I call it the CDC, not the Centers for Disease Control and Prevention, but communication, documentation, care provided. Real simple. We know these things, and I'm not going to labor all of them, but I want to make sure that we all recognize this is not just for COVID, but for everything. And I hammer these every day, but communication, simple, open, honest, revealing, transparent, whatever. We over communicate. And what we've done with COVID is we do daily or weekly check-ins with family members. We do employee huddles to dispel the myths and the rumors. We air out dirty laundry. We post on our websites. We send out letters and memos, internal and external webinars. We do handouts, social media, you name it. We do our best to convey and connect in all platforms to everyone. And then documentation, it's the most important aspect of risk management. Best defense, right? Sloppy notes, sloppy care. No notes, no care was provided. So documentation 101, gotta have accurate, timely, and complete notes. Simple. We've used that to defend in many cases. Care provided, right? Simple, care for others as you would for your loved one. It's simple. Be consistent, follow the care plans, the policy procedures, guidances, nothing new here. But what you have to do is, you may not love your job, but love what you do, how you do it, and be good at it. So that's just the simple basics, the CDC. But with respect to COVID, everyone's freaking out, and rightfully so. What we've done and is proved to be quite powerful is documentation, and not just writing simple notes. But what we've done is we've documented every key aspect that we've done, all the guidances, the timelines. That's the key point. Like, when does CDC change their guidance, and when do we activate ours or implement it? And so we recognize and we document everywhere. CDC changed their guidance for testing on blank. We implement these changes on blank. We spoke with the local health department who said blank. We spoke with the testing lab who said blank. And what was helped us stave off all these suits and basically our defense is we document everything: the who, the when, the what, the why, where, all those things. We chronicle everything. We built a library. So now these attorneys are asking us for this information. Here you go. And they sift through all this knowledge, and then they realize that, okay, these people are too good. So all that to say, build up your defense. And of course, we know all the PPE, the testing, and staffing. Those are all questionable issues that we have answers for. Documentation, right? We may not have all the PPE, all the testing, all the staffing, but we did document who, what, where, how, all those things. And we've proven ourselves that if you follow the CDC guidelines, sure, but you also follow the CDC guidelines that I put together, we're good.
Yeah, I'm going to add that to my new acronym list. I love that. A very good way to think about it, Dr. Burgess. That's fantastic. Documentation. You always hear that from the lawyer's side too. So how about Kevin? Thoughts from you? One or two strategies that our audience can begin to implement now to prepare for the employment side.
Sure. And can you hear me okay now? Okay. Yeah, I mean, my advice is not that much different from what Dr. Burgess said on the long-term care side. Documentation is key. COVID best practices are your best defense. Be vocal and communicate your commitment to safety to your employees. Let them know that what you're doing aligns with the recommendations and the requirements from the CDC, CMS, others. One of the cases I didn't get the chance to touch on involved a whistleblower retaliation claim in Chicago. One of the holes there, if what the plaintiff's saying is true, is that she sent a bunch of emails to management trying to raise these safety concerns, and they just went unanswered. Now, I don't know if that's true or not, but if it is, even if they weren't, appropriately even if they were appropriately responding to the safety issues, the optic that they're just sitting at, letting it sit there and not respond to these issues that she's raising isn't a good one. So, be thorough, document everything. Now is the time to put pen to paper. Nobody's going to remember 2 years down the road what happened in a lawsuit. So now's the time to be on top of things. And if you don't have an OSHA team ready to go, if OSHA knocks on the door, you need to have somebody ready to respond, know what to do when OSHA shows up, because 99% of the time they're not going to call you and let you know they're on their way, right? So these are the things that I think everybody can sort of implement and be on top of, because you want to be more proactive than reactive in these sort of situations.
Yeah, great. Yeah, be prepared for the knock on the door, right? So, Maria, how about some thoughts from you? And in particular, if you share your thoughts on whether we think immunity legislation is coming down the pike for all of us to think about with it.
Well, we sure do hope there is immunity legislation coming from the federal side. We haven't, the House bill and the Senate bill are sitting there, the Corona Provider Protection Act. The good news is several states have implemented their own forms of immunity statutes. My home state is not one of those, but there is some hope at the state level. Just to echo some of the comments that have been made, I think the best strategies we can have right now is to continue to be good stewards and protectors of our providers. One of the things we did in discovery in our active cases early on in the pandemic in March, and we just reissued this letter in New Mexico, is we've taken the position as a company not to allow discovery depositions of our providers during surge periods in our hospitals in states that are going through particularly large surge periods. I've authored letters, and they've attached those letters to motions for protection, and we've not had anyone really get nasty about it and file motions to compel. I think those have worked, and they protect our providers who should be focusing on the delivery of care and not worrying about discovery activity. We've created risk toolkits for early on for the process and the steps we take for patient notification if they were potentially exposed to a COVID positive provider. Even though, we went to universal masking very quickly after I think even at the time of the CDC or before. But nonetheless, we put together toolkits for notification of patients so that they could take additional steps, and notification of associates who could have been exposed. And those toolkits have allowed us to create documentation pathways where we've got all the documentation to show everything we did to try to protect both of our associates and our patients. And then one of the things I've heard, this isn't something we've come up with, but in the insurance world, we've been hearing about as we are facing what's going to happen to us in the insurance renewal world for underwriting. One of the best things I think hospitals and all sorts of healthcare entities can do is to tell their COVID story through a COVID treasure chest, which is very much what you were alluding to, but put everything in a treasure chest in terms of the charts that show the CDC guidance was on this date, and this is when we responded with our own protocol, or the state or the local ordinances and the orders that have come down on a daily basis, and this is how we've responded. So we're putting together a treasure chest not only for insurance renewals, but as a defensive measure to show the extraordinary work that's been done as we've gone through this pandemic.
Yeah, that's great. Interesting, of course, theme that continues to run through this, right? Documentation, particularly when it comes to guidance that may have been given or not given, as the case may be, by state, federal, local government. Jody, I'll turn it over to you. Again, I suspect that documentation theory that we've heard from some of the other panelists, I suspect that is music to your ears, but I'll let you respond from a fraud and abuse perspective on some practical strategies.
Yeah, I was going to say, what he said and what she said would be exactly what I would say. There is really no substitute for contemporaneous documentation. It is simply not possible to go back 5, 6, 7 years and re-put the brain in your head that existed back at that time period. And so the contemporaneous documentation of what was happening, what guidance was being issued, what you thought about it, what you did about it, how you trained on it, is just priceless. Somewhere down the line when your mental state, and in any criminal case, your mental state is at issue. So when your mental state becomes at issue, I would add to that, keep up with guidance, even as it changes. Maria mentioned, kind of the treasure chest. Keep up with changing guidance, and even guidance that is outdated, keep it. Because if you made a decision when it was outdated and you need to prove and make somebody else understand why that decision was made, there is no substitute for having it and saying, this is what we did on this day and this is why. Train your employees. If you receive a plan, a protocol, an implementation guidance booklet from an attorney, an expert, a consultant, it makes a beautiful notebook, but if it sits on your shelf, it's not as valuable as if you actually implement it and train your employees on it and document your training. Kevin said something that I couldn't agree with more, which is listen to your employees' concerns and complaints. Document your listening to them. If you find that there is no there or that there's no need to take action, that's a decision you are entitled to make, but document why you made it. Did you hear this person? What did you do about it? And why did you conclude what you concluded? And then finally, be prepared for the knock at the door. This is not something anybody wants to have happen, but if you are ready for it, when the guys with the badges show up, it's very scary, and it's hard to sort of think your way rationally through, well, what do we do? Who do we call? How do we handle this? If you have put that level of, it's a bit much to call it a crisis plan, but if you've put that level of a plan in place for the unfortunate, could happen moment, then if it does, you've got a clear sort of method of, all right, who are we going to call and how are we going to handle this and how are we going to instruct the employees? So thinking about that with cool reflection now before it becomes a hot issue is smart. And those, I think, would be my added words of advice.
Great. That's wonderful. Thank you, Jody. And some great tips in there, really some takeaways, I think, for all of you that are on your risk management teams in your organizations to take back. So we are going to sort of open this up now for any Q&A that may come in. While I'm doing that and seeing if we have any Q&A that comes in, our panelists have been so gracious in offering up their time and wisdom today. And I have listed up email addresses should any of you have a desire to follow up with a particular question that you have not submitted otherwise to the panelists through the course of the program today. Please feel free to do so. I also say please do take a moment to join us for our next sessions. Our next one will be on Thursday, October 29th. And a reminder about CEU credits. Please submit for those. So we do have one question so far that has come in, and I'll open that up, see if any of our panelists have thoughts. And it really is whether or not any of us on the panel, they have been considering using the defense of impossibility to reach the standard of care based on the inability to obtain PPE testing, et cetera, and from the federal or the federal government. So thoughts, I guess, about the impossibility defense. Does that strike a chord with anyone?
I think, if I can comment, I think we will see different defenses. I think whether we call it an impossibility defense or a crisis standard of care, I think we will be defending on new standards of care. And Randy, I think the way to prepare yourself for that is to really put together your timeline and your treasure chest. Like Jody mentioned and Tony mentioned, you've got to have that timeline of what you were experiencing at that time in terms of, was your supply chain having a problem with obtaining PPE or testing kits on April 15th of 2020 versus, 4 years down the line when you're in the middle of the litigation? If you haven't put together that timeline in that treasure chest with all of the documentation to support what you were experiencing at that moment, you won't have what you need for a robust defense. So I think there is work to be done now as we predict what might happen.
Thank you for that. I appreciate that response, Maria. Well, we have run short on our time, and I want to respect everybody's calendars. Again, a huge thank you to our panelists, Maria, Dr. Burgess, Kevin, Jody. Thank you for your time and your wisdom to our attendees today. And thank you again for everybody for joining us as part of the Husch Blackwell virtual seminar series. And we look forward to seeing you again next week as we move on to talking about strategic acquisition and investment opportunities. So thank you and have a wonderful day. Thank you.